The issue on this appeal is whether the Times enjoys public interest privilege, often called Reynolds privilege, in respect of an article defamatory of a senior police officer. The article was published by the Times in June 2006 in print and on its website. It was headed "Detective Accused of Taking Bribes from Russian Exiles." It reported that Scotland Yard was investigating allegations that a British security company with wealthy Russian clients had paid a senior police officer in the police extradition unit for sensitive information. The allegations were reported as coming from a former insider in the security firm who had passed a dossier to the police and to the Times' journalists. The officer was identified by name as the respondent, who was said to be friendly with one of the security firm's bosses. The information was said to relate to efforts by Russia to extradite a number of wealthy Russians living in Britain. The article went into detail. The article further recorded that the officer had been moved temporarily from his post and that he denied any wrongdoing. In December 2006, the police reported that they were unable to find any evidence to substantiate the allegations against the officer. The Times, on learning this in September 2007, failed to remove the article from its website, but the present appeal is only concerned with the publications from June 2006 up to September 2007. It is common ground that the article was defamatory. It implied that there were strong or reasonable grounds to believe that the officer had abused his position, or at least grounds objectively to investigate him on that score. An article enjoys Reynolds privilege where it is in the public interest that the information in it should be published and the publisher acts as a responsible journalist. In October 2009, Mr. Justice Tugendhat concluded that the article enjoyed such privilege. In July 2010, the Court of Appeal reversed him. It considered that there was no public interest in the publication of detailed allegations, the subject of an incomplete investigation, in circumstances where the Times was relying on information from a source beyond which its journalists had not gone. The Supreme Court unanimously restores the judge's conclusions. The judgments highlight several points. First, the article concerned a subject of high public importance and interest, possible corruption of the police in relation to the operation of the extradition unit. Second, public officers with a role as important as the police's must expect their conduct to be open to close scrutiny by the press. That is part of the press's role as a public watchdog recognised in a series of cases domestically and in the European Court of Human Rights. Third, the judge found, and the Court of Appeal had no basis for doubting, that the story was published with the legitimate aim not simply of informing the public, but of ensuring the proper investigation by the police of serious allegations against one of their number in circumstances where the journalists had some reason to doubt whether this was in fact occurring. Fourth, journalistic judgment and editorial freedom are entitled to weight when a court considers whether it was in the public interest to publish the detailed allegations contained in the article. It was doubtful here whether the article would have been publishable or would have achieved its purpose without details of the allegations, including the names of those involved. Fifth, the journalists believed the information published to be true and had acted reasonably and gone as far as they could in the steps taken to verify the information given them by informants, particularly the security firm Insider. No more was required in principle. Sixth, while it was incumbent on journalists to weigh the potential damage to reputation in respect of allegations the subject of ongoing investigations which might lead nowhere, there was no principle that journalists must postpone any publication until after the conclusion of such investigations. Seventh, the article was balanced in content and tone, did not assert the truth of the allegations of impropriety, but identified them as the subject of an investigation in progress. The officers and all others involved in the story were given the opportunity of commenting, and their denials of impropriety were in each case recorded. Any admissions there may have been in the reporting were minor. In the result, the judge did not err, and the Court of Appeal had no justification for departing from his findings or conclusions. The appeal is allowed, and the judge's judgment in favour of the Times restored.